Let's bring in trial attorney Michael Jaafar, who is standing by to talk about what we're hearing. Michael, an expert witness who doesn't know the facts of the case, just being brought in to educate the jury. I've seen this sometimes, perhaps on date rape cases, to help the jury understand rape culture, or the judge brings in an independent witness to understand a scientific fact. But what do you think about it being used here?
Propensity evidence is generally not allowed in cases like this, especially a murder case. Georgia, I think, follows the federal rule because propensity evidence is generally not allowed. There are special carve-outs for domestic violence cases. It's going to be a big decision for the judge to see how she carves this, whether or not she allows a small, little, limited exception. But at the end of the day, there was no conviction. There was allegations. And there are instances when people complain about domestic violence and they are making it up. I'm not saying that happened here, but there are instances. And that's why the system and the law does not generally just allow you to say, well, there was a complaint for domestic violence and they're bringing in an expert now to testify. And it's going to make it seem like he beat his wife just by the testimony of the expert. That's what the defense attorney is saying. I think he's going to win this argument. I could be wrong. There's a small carve out from the judge to let it in because it's a domestic violence, but I don't think she's going to let an expert testify in this manner because it would be too propensive against the defendant.